Well, Tom and Jen, the AG's office filed a 7-page letter of objection to what Mr. Mazzaglia is trying to do, saying it essentially flies in the face of the state's concept of justice. If he gets his way, convicted killer Seth Mazzaglia won't have to sit through a sentencing hearing in which he would have to listen to family members of his victim, Lizzie Marriott, describe the depth of their loss.
He knows he's going to get at least mandatory life without parole. So really for him, the sentencing hearing is going to be an hour-long exercise of, essentially him being criticized for his conduct and having to face up to the families of the victims. That's why he probably doesn't want to go.
Former Assistant Attorney General David Ruoff says the move is not unprecedented, but he's never heard of an instance that has been successful. In this case, Mazzaglia's lawyers argue that he has rights under the U.S. and New Hampshire constitutions to opt out of attendance. But while a convict has the right to attend a sentencing hearing, there is no explicit right not to attend. It's up to the judge to decide, and the issue isn't quite as black and white as it might seem at first glance.
The trial judge is going to have to consider the safety aspect of this. If he's going to be sentencing a man who's going to get life without parole, there's really nothing much more dangerous than someone who has nothing else to lose. So the court has to be concerned about whether or not he's going to act out.
The state is fighting Mazzaglia's request, saying this is about accountability. And it's a lot more than just accountability. There are numerous other reasons listed by the Attorney General's office in this objection. David Ruoff says that prosecutors are going to fight this tooth and nail, though, because if they don't succeed, it could set a precedent for all future first-degree murder convicts in the state of New Hampshire. Reporting live in Concord, Adam Sexton, WMUR News 9.